Right, so we are continuing with our next substantive topic, forms of business organization. We'll be looking at brief introduction to factors of production, the modes or model of business organization. Yeah, so these are the essential legislation that you have to look at. Now, to start with, from from basic economics, right? We get the idea that when we mention production, is simply creation of goods and services to satisfy human needs and for human consumption. That is very pretty straightforward. And to be able to have production, you need certain things, and those things are called factors of production, or the inputs or resources that are needed before we can have production. Yeah, we can have creation of goods and services. And you have production either to make economic profit or to achieve a social objective, as the case may be. So therefore, economists will tell us that we have 4 factors of production, namely land, labor, capital, and entrepreneur. So these are the 4 things we are usually told by economists. And persons with capital, land, and labor may want to invest in a commercial enterprise that will generate returns or bring about some other desired social benefits. A major decision will have to be made regarding the mode of enterprise, the type of enterprise, or the type of business vehicle a person can use to channel capital or available resources into production. So it is possible for a person to channel his available resources, that is the capital, labor, and land, maybe through a vehicle we call company, or just as a sole proprietorship, or some partnership arrangements in order to gain the economic profit or the desired social objective that we've talked about. So, simply put, the availability of resources for production instigate the desire to operate or set up a particular business model. Once you have the resources there and you need to turn it around to either generate profit or achieve a certain social goal, you necessarily need to make a choice regarding how you are proceeding. And how you are proceeding is what we are interested in this topic, business organization or models of business organization. So maybe before we proceed, let's do a little bit of brainstorming exercise. So in a business organization, how does the entrepreneur unite the factors of production for a good economic return or to achieve a social objective? Yes, anybody? Let's take a 1 male, 1 female. Just put up your hand and then, or let me say you can unmute yourself and make sure that only one person is talking and don't create a background noise. Yes? Any attempt? Yes. Anybody?
Hello, my lord.
Yes, Mr. Ibrahim, proceed.
My lord, thank you very much for the opportunity given. I think you have to look at the location of where you want to set up your business.
Okay.
And how available there are labor to that effect.
Yeah.
Looking at the location and the labor, they look at how you can maximize your labor in respect of making profit. as to the availability of markets.
Okay. But then there's a follow-up. You said that situate your answer in the context of 2 or more modes of business organization. You know, we have hinted at some.
Yes.
Yes.
As to a sole proprietor, you need to look at where your business, your product will be needed and how available the market is. You look at it vis-a-vis the location of the land or where you want to set up the business and how available the labor you are trying to use in bringing out the production into effect.
Okay.
When it comes to company, I think you need to also look at the existence of the market vis-a-vis the competitiveness of other competitors in that area of business. Okay. And you can also look at how relative the labor forces are to reach the cost of production in order to make your product more viable for consumers and customers.
Okay. Right. That's a good attempt. Yes. Thank you. Any other person? I prefer a female voice now. Yes. Any lady? Okay, Juliet. Kunadi Boachi Yadum.
Hello, sir.
Yes.
Okay, sir. My lord, please, with the sole proprietorship, you can also look for the challenges around in your vicinity or community and turn them to opportunities.
Okay.
Say, if you live in a place where people walk so many miles to buy charcoal or so many miles to buy stuff they don't have in that vicinity, you can also turn around and then go for the same item and then start selling at your community.
Okay.
That is looking for the challenges in the community and turning them to opportunities.
Okay. All right. Thank you, all of you.
Thank you.
Good. So let's look at the.
Hello, my lord.
Yes.
Yeah,
Yes.
I think for an entrepreneur, he will first do a need assessment to identify the market gap or consumer need, so that he will try and produce that in order to maximize profit.
Okay. All right. Yeah, that's correct. Right. Thank you. Good. So let's quickly walk ourselves through some of the conventional or the traditional modes or models or forms of business organization. So let's start with the sole proprietorship. If we look at the Black's Law Dictionary, a sole proprietorship is a business organization whereby a single person owns and runs the business with the aim of making profit, bearing the risk, and enjoying all the benefits accruing from the business. So that is a very comprehensive explanation for sole proprietorship. So one person is the owner of the business. He or she also runs the business, of course, with the aim of making profits. And that person also has assumed the risk of bearing any debt or liability which will come to the business. And also, he alone will enjoy any profits which the business will generate. It is unincorporated in the sense that the business is not seen as a separate legal entity. from the person running the business or the person who runs the business. So the same person provides the capital and all the other resources. Once they manage the business, there's no distinction between ownership and management. And by definition, sole proprietorship has no members apart from the sole proprietor. Despite the fact that he or she may employ other persons, he can employ as many people as he needs in the business, but ultimately, he is the owner. He is the management. And the persons employed, as we've stated, are not members of the business. Technically, there are no legal requirements in establishing this business model. We don't have specific legal requirements you need to meet before you can start running as a sole proprietor. However, if you choose to have what we call a business name, that is, you choose to abandon your original personal name as a sole proprietor. You choose to abandon your name as Ajua Menu, Akuya Pinamai, Akuya Usua, or Ajuata, as it were, and you want to maybe adopt a certain name like Ave Maria Enterprise or Hotel the Angels or something like that, then you need to comply with Registration of Business Names Act of 1962 at 151. And according to Section 4 of the Registration of Business Names Act, such a chosen business name is supposed to be registered by the sole proprietor or the person who is seeking to register it within 14 days after commencement of business. So a fee is prescribed, which you have to pay for the registration. You can also apply to change the name, and you are supposed to also apply for renewal of the name every year, as it were. So if you look at the Section 2 of the Registration of Business Names Act at 151, it sets out the particulars to be registered with the registrar. And these include the business name, that is the chosen name. So the business name is a name other than your rare or original name, the general nature of the business, the principal place of the business, and the particulars of the proprietor, your address, where you stay, and so on and so forth. Now, pursuant to Section 5 of Act 151, the registrar can refuse to register a proposed business name if, in the view of the registrar, the business carried on or to be carried on by the person seeking to register that business name is unlawful, misleading, or undesirable. So, for example, you are going to do the business of selling, ice cream, okay? And you propose a names like Modern Medicine Specialist Enterprise. Modern Medicine Specialist Enterprise. That is your proposed business name. Meanwhile, the business you said you are going to do is selling of what? Ice cream. You notice that there is no significant relationship between the business that you propose to do and then the proposed business name. And for that matter, the registrar will be justified in refusing to register that business name. Of course, where the registrar has refused to register your business name, you can, and you are aggrieved by it, you think that maybe the registrar has made a wrong judgment, you can always seek a redress in the High Court for the necessary intervention. And the decision of the High Court will be final. Now, it is important to note that where you are successful in getting your proposed business name registered, the registered name has a lifespan, and that is 1 year, meaning that every year you must renew it. If you don't renew it, the registered name will lapse, so to speak. Now, is there any legal effect when you have registered your business name under the Registration of Business Names Act at 151? Well, we need to note that such registration only confers the right to exclusive use of the name. Exclusive use of the name. That is to say that you, the person who got that name registered, you are the only one who in law is eligible or is qualified to use that particular name. And of course, you remember thought of passing off. Can somebody tell us what the thought of passing off is before we move on? Now, I've told you, for me, I like testing your knowledge in all relevant areas of the law as I'm teaching you. Yes, thought of passing off. Anybody? I should just put up your hand. Otherwise, I'll call you. If you don't put up your hand, I'll rather choose someone. Any hand up? Okay.
Please, can I try?
Okay, now Densua and then Ibrahim. Now Densua. Now Densua, go ahead. Now Densua, please go ahead. Oh. She has abandoned her mic. Okay. All right. Okay, those. All right. So the hands up. No, but Ibrahim Tijani, did you want to speak?
Yes, please, my lord.
All right.
Passing off, I think it's a civil wrong or thought of. It's a thought that is committed, which is related to a trademark law, which involves one trader somehow misrepresenting its goods or services as being those of another trader in order to actually take away that competitor's customers or potential customers by way of misrepresenting himself or her product.
Okay. So in terms of name, how does the name plays a part in that thought?
It's semblance. It's like it's almost similar to that of the competitor trademark or name, so as to misrepresent his or her goods as that of the competitor in order to tweet off potential customers or rare customers of the customer or of the competitor.
Okay. All right, good. Yes, Vanda Kwaku Ankoma Abroka, you want to add something? I think your hand is up. Yes, you can unmute. Kwaku, your hand is up. Yeah, you can unmute. Okay, now let me, Juliet. Juliet,
Yes, sir.
yes.
My lord.
Hello, sir.
Okay, sir.
Yeah, Juliet, go ahead, and then after that, Vanda, yeah.
Okay. The liability of passing off arises when goods or services of a person are presented in such a way or manner that they are likely to be mistaken for the goods or services of another person.
Okay. All right, good. Yes, Kwaku, you want to say something? Well, could you want to say something? Go ahead.
Hello, sir.
Yes.
Hello, my lord.
Yes. Yes,
Okay,
proceed.
my lord, my name is George.
George, okay.
Passing off is like using someone's trademark as your own in order to sell to make profit. Let's say, for example, the name like Nike, Nike. Somebody might use that product and change the name to, let's say, Nike, which in the eyes of the market, people might think they are in to buy the same Nike. But in a way, he's deceiving most of the markets in order to sell his products at his own.
Okay. All right. Thank you. Good.
Okay.
Yeah. So, just to illustrate the point you've made that where you have registered a business name and the Registration of Business Names Act at 151, it gives you just the right of exclusive use. It does not make the business separate and distinct from the sole proprietor. So the mere fact that we've registered a business name does not mean that the business has now assumed a separate entity from you, the incorporator. And for that matter, in the well-known case of Barclays Bank of Ghana Limited against Latte and others, 1978 to Ghana Law Report 282, the court made the point that a business name registered under the Registration of Business Names Act did not, by the act of registration, acquire any legal personality distinct from the person registering it. Now, as you go and read that case, I hope when I say go and read, I mean you should read it. You notice that there was a registration of the name called the SCATS. And later on, when Barclays Bank sued, an issue came up as to whether the person who had gone for the facility could be sued and not the business called like the SCATS. That should be sued. And the court went into it and realized that it's just a name which had been registered under the at 151. So read that case in full and brief it, please. And again, it also underscores the fact that where a business name is registered, it does not create proprietary interests, which could be transferred or alienated. So if I have a business name which I have registered, it's not something that I can transfer to you. So it's not transferable, unlike a business which has been registered so that I can transfer my shares in the business to you. So let's take note of that. So therefore, in the case of Bedu against Sam, the plaintiff, the policeman registered a business called the Unity Salt Industries. He registered that as a business in Unity Salt Industries under 151. And later on, the policeman purported to sell the business to the defendant without the plaintiff's consent. So it was held that if we look at provisions of at 151, such a business name could not be sold because it was not a chose in action, like a copyright or patent. You can sell your copyright or patent as it were, but a business name does not give rise to any proprietary interest. So there was no personal right or property in the mere name so as to sell or purchase it. And for that matter, the plaintiff's claim for declaration that the sale of Unity Salt Industry was void could not be sustained in law. Yes, Akonoba, let's hear you.
My lord, please, I had the opportunity to read the BBG versus Latte, the Barclays Bank case.
Okay.
And I stand to be corrected. The court said that the liabilities of the former.
Can you tell us briefly about the facts? Briefly. tell us about the. Yeah,
Okay,
because
my lord, thank you very much.
yes.
Yeah, my lord, per what I read, the man registered, the man was deceased and he registered his company as a sole proprietorship. And when he was, during the time he was alive, he procured a loan from Barclays Bank, and the loan was on the sole proprietorship company, sole proprietorship. So when he died, his estate changed the name from a sole proprietorship into a company. And Barclays Bank went after them to reclaim the amount that Latte owned them. And the argument of the defendant then was that so far as at the time that he procured or he applied for the loan, it was a sole proprietorship. Now, a new company as he made, which is not sole proprietorship, so they cannot come and claim the liabilities. But the court said that no, it was just a mere change of name. But the liabilities that Latte to Barclays must be paid by those who have taken over the new company.
Yes, that's correct. Thank you. Yeah. The solution of sole proprietorship, as we have indicated, just as there are no legal requirements for setting up a sole proprietorship, in the same vein, there are no legal formalities for dissolution of sole proprietorship, for ending sole proprietorship. Of course, you set up your business as a sole proprietorship. You can decide to end it any day, anytime. The person travels or the person says, well, I'm no longer running, and that is it, it dies. You don't need to go through any process, especially if you're not owing anybody. But where the sole proprietor had the registered business name, then steps will have to be taken to remove the registered business name within 3 months after cessation or dissolution of the business. And that is what section 10 of at 151 stipulates. But the point to note is that where you have dissolved the business of the sole proprietorship, it does not by itself absorb the sole proprietor, that is the businessman or woman, from private and public duty liabilities, which arose in the course of business before the dissolution. What do you mean by this? That is to say that if you were indebted to people, the mere fact that you sold the business would not end the debts. If you had defaulted in paying taxes, the mere fact that you have stopped the business would not absorb you from your past tax arrears or past debts, past tax, unpaid tax. You have to pay it. In the same vein, if you are owing your employees, they can still sue you to collect their unpaid salaries. Same also applies to undischarged contractual liabilities. Certainly, we have some advantages of sole proprietorship. Very easy, simple, and relatively cheap to set up, and decisions thrive because it's the one person who is making it and he is going to implement it. You don't have to go through the various organizational formalities and complexities. As we come to discuss the incorporated company, you notice that there are certain decisions which will require certain type of majority, like special resolutions. You require about 75% of the members and all that, and certain advance notices will have to be given before meetings are held. All those complexities are not present when we are dealing with sole proprietorship. And again, we've seen that no special formalities are required before we can set up a sole proprietorship business. And you can even set up, start running your business before you even go through registration of a business name. On the flip side, there are some disadvantages or demerits of sole proprietorship as a model of business organization. we have seen that the liabilities, that is the debts of the business, are not considered debts of the business. They are considered debts of the sole proprietor, the businessman or the businesswoman. So there's no separation between your personal debts and then the debt of the business, unlike where you have like companies. So that is a rare challenge. Now, there's also lack of, and let me say this. So if you decide to use the sole proprietorship business, it can make your life horrible if, for example, you incur so many debts, you are sued, and people can even attach your personal assets in satisfaction of the judgment debt. Again, there's also lack of business continuity upon death. If the sole proprietor is sick, the business is sick. If the sole proprietor dies, the business dies. So those are some of the disadvantages. Now let's move on to another model of business organization, what we call incorporated private partnership. Now let me say that in Ghana, anytime we are talking about partnership, we talk about incorporated private partnership. So let us keep that in mind. And the governing legislation is the Incorporated Private Partnership Act, 1962 Act 152. Now, according to Section 1, subsection 1 of that legislation, that is 152, a partnership is defined to mean the association of two or more individuals carrying on business jointly for the purpose of making profits. So that is very important. Association of two or more individuals. Of course, it should not exceed 20. You see that in the course of time, should not exceed 20. So from 2 to 20, they've come together to do business for one purpose, and that purpose is to make profit. So within the meaning of the Incorporated Private Partnership Act, partnership is not for doing any charitable causes. No, it's for doing business to make profits. So let's keep that in mind. So all partnership associations are profit-oriented, and for that matter, could not be formed for any social non-profitable objective. And again, if we look at Section 2 of Act 152, the maximum number of partnership is 20, and the minimum number is 2. So let's keep that in mind. It is conceptually flawed for you to call one person as having partnership. No, partnership must always have more than one, but it should not be more than 20. So from 2 to 20. And this is a prescription of the law, Section 2 of Act 152. So let's keep that in mind. And again, the main purpose of partnership is to carry on business. And business in this context refers to any trade or profession. So let us keep that in mind. So if we look at Section 59, if we look at Section 59 of the Incorporated Private Partnership Act, it will define business as referring to any trade or profession. And that is why you can get accountants, you can get lawyers, you can get engineers, various professionals registering partnership as incorporated private partnership as a way of plying their trade. So if we look at the case of Smith and Anderson, for example, a society was formed to purchase investment for the common benefit. And the court held that the society was not a partnership. Why? One of the judges, Lord Justice James, observed that there was nothing to be done by such societies that come within the ordinary meaning of business, any more than what is done by trustees of a marriage settlement, who have large properties vested in them and who have very extensive powers of disposing of the investment according to their discretion and judgment, unquote. So just to re-emphasize the point that the main purpose of partnership is to carry on business which is profit-oriented. So let's keep that in mind. And similarly, in Keith Spicer against Mansell, the court held that there's no partnership when it is merely shown that the persons concerned were only preparing to carry on business as soon as they could. So that also did not meet the threshold or the criteria of a partnership. Another point to note is that when it comes to the business of partnership, it should be carried on jointly by the partners. So in Ghana, we don't have the concept of sleeping partners, okay? When you go to some jurisdictions, UK and other jurisdictions, and you meet the concept of sleeping partners and all that, that is to say that those partners who just contribute towards the capital of the partnership, and yet will take a backstage, will not play any role in the managerial direction of the partnership business. No. In Ghana, we have a radical modification of the common law type of partnership, such as active partner, sleeping or dormant partner, and nominal partner. We don't have those things in Ghana. All partners are supposed to take part in running the business of the partnership. And for that reason, there are certain associations or arrangements which may seem to be partnership, but under our law are not so recognized as partnership. So if you look at section 1, subsection 2 of Act 152, it provides lists of excluded potential partnership. So for example, they're told that an association of members is not a partnership if it is a registered company. So if you have like a registered company, yes, it may take all the things you've said, but that per se would not be partnership. A company that is a body corporate or unincorporated association formed under any other enactment is also not a partnership. A body corporate formed in accordance with the law of a foreign country, whether or not carrying business in the public, is also not a partnership. And a joint without a firm name for one or more specific operation is also not a partnership. So let's keep that in mind. So you can have maybe like they have what you call the MOU, right? Or something what they call like the JV, joint venture agreement. That per se is not partnership. So if you have like a JV agreement, joint venture agreement, it's not partnership within the entailment and the purview of the Incorporated Private Partnership Act of 1962 at 152. So let us keep that in mind. Similarly, if you have family co-ownership or family ownership of property or co-ownership of property, that does not create partnership. What do you mean by that? Like, let's say that there's a property owned by the family, yes, it generates profits and all that, or 2 or 3 people own a property, right? It generates profits and then they share. Now that does not necessarily translate into a partnership, because partnership is a term of art in the sense that it has assumed a technical meaning. Technical meaning here is where you have complied with the requirements and the regime prescribed under at 152 before you can have that business model called Incorporated Private Partnership. So what is the test, the proper or the legal test of partnership then? Yes, the sharing of business profits and participation in the conduct of business is prima facie evidence of partnership. I said prima facie, but that is not to say that that is all. Of course, we are taking for granted that you have gone through the other things that we are talking about. So every partner, as we have indicated, must participate in the management of the partnership firm unless it's otherwise agreed. But active or sleeping partner, nominal partner, those things, as I said, they don't really apply. And again, the remuneration of a servant or agent of a person engaged in business by share of profits of the business does not of itself make the servant or agent a partner. Maybe if you have like a commission agent or something, someone is supposed to get customers to come and buy your goods, and now you give the person a commission. That does not mean that there's a incorporated private partnership between you and that person. No. And that is what section 1, subsection 4 of Act 152 is referring us to. Now, how is incorporated private partnership established? Yes, there's a registration regime which you go through, very simple. You get the requisite forms from the registrar, and then you must have the name of the partnership. You must have a statement of the general nature of the business. What is the partnership going to do? Of course, the various addresses of the partners, and also the place of business of the partnership. All those will have to be stated in the forms that you fill. And if there are any charges which are supposed to be registered, maybe like probably whether some loan has been granted and maybe some assets of the business have been used as a security and all that, all those things will have to be stated. So since partnership is first of all based upon an agreement, right? You must have like the partnership agreement. It can be vitiated by fraud or any of the vitiating factors that you know. And any partner who discovers that he entered into the partnership agreement as a result of fraud or some misrepresentation can take appropriate steps to have it rescinded. So look at section 41 of Act 152. Who has capacity to form a partnership? In other words, who can be part of incorporated private partnership? Well, in terms of section 3 of Act 152, if you are not within the listed category of persons disqualified or as being ineligible to form partnership, then you qualify to form partnership. So who are those who are disqualified? Infants, someone below the age of 18. Now, at least that's the sense we get from Act 992, despite the fact that, and then also the Children's Act. A person of unsound mind, a person within the preceding 5 years who has been guilty of fraud or dishonesty, whether convicted or not, in connection with any trade or business. Of course, if you look at section 3, subsection 3, paragraph D, subparagraph III, in the light of recent Supreme Court decision on similar provision in the Companies Act, that it is unconstitutional to say that if a person has been charged with an offense and the person has not been convicted, that disqualifies a person from being appointed an officer or director. So going by that, one can safely hold the view that this aspect of section 3 is also unconstitutional, especially the aspect which says that whether convicted or not. If a person has not been convicted, how can that be a ground to disqualify the person? Then undischarged bankrupt. Undischarged bankrupt. If you have been declared bankrupt. In other words, you're owing so many people, they make demands on you, you're not able to pay your debts, and then you run away to seek protection of the law, and you declare yourself bankrupt. Then, so long as you have been declared bankrupt, meaning that you are not creditworthy, you are not able to pay your debts and all that, you don't qualify to enter into partnership agreement. Again, a body corporate, that is a company or registered partnership, cannot be a member of a partnership. So let's take note of this. In the case of incorporated company, if you have like a company, like I gave you an example, a company can be a shareholder in another company, okay? But when it comes to partnership, a company cannot be a partner. And an incorporated or registered partnership can also not be a partner in another registered partnership. So the point is, a body corporate cannot enter into partnership agreement. Yes, when you submit your application to the registrar can refuse to register you for similar reason as we saw under at 151, maybe where the partnership does not meet the test of partnership under the law, the registrar can refuse you, or the business you propose to carry on or to carry out is unlawful, that can be a ground for refusal, or the name of the firm is misleading or undesirable, that can also be a ground. Or if any of the partners is not qualified and the person comes within the list of unqualified persons, then the partnership will not be registered. Or if you don't do the paperwork well, so that it cannot be read, then that can also be a ground for refusal. So what happens where you are successful and then the partnership is registered? Well, when it is successfully registered, then the partnership becomes a body corporate, separate and distinct from the partners. So the business of the partnership will be seen as a legal entity, so to speak, capable of exercising the powers of natural person of full capacity. All that a body corporate can do, the partnership can also do that. So look at section 10 of Act 152. Now, despite the fact that a partnership firm is a corporate, a body corporate, it is important to note that there is no limitation on their liability. So unlike other jurisdictions like UK, where they have the LLP, limited liability partnership, okay? A partnership in which some of the partners have capped how far they can be held liable. In Ghana, we don't have limited liability partnership. That is to say that when there are debts or liabilities, all the partners will have to bear it without any limitation. So let's look at section 4, subsection 1, section 10, subsection 3, and section 14 of Act 152. But the good thing is that it is possible for the partners to have what we call indemnity agreement. What do you mean by that? That is to say that if third parties can demand whatever debt the business is owing from any of the partners, there can be agreement that, okay, when we are so sued or we get exposed, then you are going to pay back to us whatever we have lost on account of the debts of the the partnership. So that is like the indemnity, like the arrangement. Now, with respect to liabilities of incoming and outgoing partners, it's possible for some of the partners to leave and for more to join. Please look at section 15 of the legislation. Now, what happens where you have a partnership, right, which is running, but it has not gone through the registration requirement? Well, the case of Bedu and Sam provide a very important learning for us. And it underscores the fact that under Ghanaian law, there is prohibition on operationalization of unregistered partnership firm. If you have a partnership firm and you've not registered, in the eyes of the law, is no partnership at all. And that is the import of the combined effects of Section 4, subsection 1, and Section 7, subsection 1 of Act 152. So where you don't register your partnership, there are consequences. It's a crime. You could be fined. And also, the law will not allow you to enforce any rights which you may have under the partnership agreement because you haven't registered that. So if you look at the case of in-race Sasutrim disease, Sasutrim and Trim, an agreement was made by the husband and wife to operate a shop as partnership, but was not registered under the registration framework of Act 152. Now, the wife sought to rely on partnership to claim half of the value of the shop on the death of the husband. And the court held that since the partnership agreement was never registered, neither of the partners could enforce any right arising out of the said agreement. So the plaintiff could not rely on the partnership agreement to claim half of the share of the value of the shop. So the takeaway is that an unregistered partnership under Ghanaian law is no partnership. So let's keep that in mind. How does that partnership firm come to an end? How is it terminated? It's terminated by winding up and subsequent dissolution by the registrar. So see sections 42 and 49 of Act 152. And how is the winding up done? It may be as a result of insolvency proceedings against the partners jointly, where creditors of the partnership firm or even like the states gets so concerned that they are not able to pay their debts and all that. So insolvency proceedings are brought against them. And that automatically will have the effect of terminating the partnership firm. Or an application may be made to the High Court and an order may be made that it should be terminated. Or there could be voluntary liquidation by the partners. The partners may sit down and say that, okay, our business is not owing anybody. But if it's owing anybody, we have some assets. Let's sell all of them. Let's pay our creditors. And now, if something is left, let's share the money. Everybody should go his way. The partnership is over. So please see section 44, 45, and 46 of Act 152 on the various modes of winding of the partnership, which I have summarized. Again, if we have a moribund or defaulting partnership firms, that can also be dissolved pursuant to intervention of the registrar. So if you look at section 50 and 51, if you have like a partnership firm, which is just existing in name, the registrar can take the necessary step, will post a letter to the registered place of business about 2 or 3 times, not getting any feedback, will go ahead and have the strike off on the register of incorporated private partnership, and it will be so dissolved. Now, what happens when winding up proceedings are commenced against the firm? where a petition is brought in the court for winding up of the partnership. What happened? Yes, the partnership firm, once proceedings are commenced, cannot continue to carry on business. If business will be carried out at all, it is for the beneficial winding up of the firm. When we say beneficial winding up, that is to say that it is meant to gather in assets to pay any debts or liabilities of those who may have a claim against the partnership firm. But because it is incorporated and is a body corporate, its status as a corporate entity, so to speak, and its corporate powers will continue until it is dissolved. So there will have to be a specific act of dissolution to say that it is dissolved before its corporate status will come to an end. Again, on winding up of a partnership firm, every partner and every former partner or the legal representative, if not paid of an interest due him under the partnership agreement, is entitled to claim such interest. So where the partnership is wind up will mean that yes, there are assets, right? You have like a positive balance. You can pay all the debts and liabilities. So something may even be left. So if your partner, for example, an interest or a share of profit is supposed to be paid to you, it has not been paid, and there's an arrears which you have, you're entitled to actually claim that. So look at section 48 of Act 152. Now, there are obviously advantages of using incorporated private partnership as a model for running a business. And as we have seen, where the partnership is registered, it assumes the status of a body corporate. And that means that the firm is separate and distinct. Is separate and distinct from liability of the partners, if you like, as individuals, as it were. So look at the case of Akapu and Solar. And again, there is business continuity even after the death or cessation of a partner as a member of the partnership firm. So if a partner decides to pull out or a partner dies, that in itself will not bring an end to the partnership firm, unlike a sole proprietorship. I'd like you to look at the case of Mensa against Edu and compare that with the case of Akapu and Solai, okay? On the question of whether or not the death of a partner ends a partnership firm. So I'd like you to look at that, that case. And when we have our next class, I'll ask you about it. And at this stage, let me ask you if you did the work that I asked you to do yesterday. Yesterday, I gave you a small work. Let me call out one lady, one gentleman. Okay, so Akuya, whoever Akuya is, yes. Akuya.
My lord.
Yes. Tell us about yesterday's work.
Yesterday's work, some of the facilitative provisions in Act 992, Section 6, right to form a company. One or more persons may form an incorporated company under this Act. And Section 7 also talks about types of companies. Section 7.1, an incorporated company may be a company limited by shares, B, company limited by guarantee, C, an unlimited company, or D, an external company. Section 9 also talks about conversion of company limited by shares of company limited by guarantee. So section 9(1), a company limited by shares may be converted into a company limited by guarantee if A, the liability on any of its shares is fully paid, and 9(1)B, all the members agree in writing to the conversion into the voluntary surrender to the company for cancellation of the shares held by them immediately before the conversion. C, a new constitution appropriate to a company limited by guarantee is adopted by the company pursuant to section 30.
Okay.
Pre-incorporation contract.
All right, clear. At least you're giving me evidence.
Okay.
You've
Okay.
done the work. Okay. So let's take Richard one from Wachi. Okay, he's not talking. I'll continue. So please look at this new tax I have given you. In terms of disadvantage, the major deficiency or disadvantage related to incorporated private partnership is that liability of the members are unlimited. And what that means is that where the assets of the firm could not satisfy the debts or liabilities, it falls on the doorsteps of individual partners. That is a rare disadvantage, making it similar to sole proprietorship in terms of absence of limitations on the liability. Okay, we'll draw the curtain down here, and then we'll continue Saturday. So Saturday, I would like you to make a bit of sacrifice. What is happening is that we have what you call like the legal